Please practice the words on screen by pausing the video as it will be helpful in the dictation of this exercise. Be ready for the dictation. 5 seconds to go. Okay, let's start. The plaintiffs claim that the Indian defendant number 2 company is under the control of wrongdoers. They further claim that defendant number 8 to 10 were in active collusion with defendant numbers 3 to 7 and that they have joined hands to deprive defendant number 2 of its beneficial interest in the suit shares, namely 6% of shares of the Indian company. The plaintiffs have further stated that they came to know from newspaper reports that the equity of defendant number 1 was to be sold to private equity investors through a bidding process and that defendant numbers 3 to 7 along with defendant numbers 8 to 9 were attempting to sell their investments in the Indian company. It was urged that in case such a sale was to happen, defendant number 2, which had financed the purchase of such shares, would be put to loss of its beneficial interest was not recorded in the books of the Indian company. While filing the suit, the plaintiffs had filed application number 292 of 2018 seeking leave to institute the suit within the jurisdiction of the High Court of Judicature at Madras. In the affidavit filed in support of that application, the plaintiffs had stated that they had sought a declaration that defendant number 2 had a beneficial interest over 6% of shares of the Indian company. Para. However, the shares might be alienated. It was further stated that substantial part of cause of action arose within the jurisdiction of the court where the registered office of the first defendant was located and where it carried on business. Further, the entire subject matter of the suit was the shares of the Indian company which are held by defendant numbers 3 to 7 and that defendant numbers 3, 5, 6 and 7 normally reside in Chennai. It was further stated that the correspondences between the plaintiff number 2 and the Indian company through defendant number 10 also took place in Chennai, claiming on this basis that substantial part of cause of action arose within the jurisdiction of the High Court. Leave to institute the suit was sought. The single judge court granted leave. As noted above, the contested defendants filed applications for revocation of the order granting leave to the plaintiffs. The Indian company in the affidavit filed in support of A number 1387 of 2018 para. It was urged that order granting leave should be revoked on this ground itself. It was further stated that there are no disputes with respect to the ownership or management or shareholding of the Indian company. It also took the stand that the plaintiffs are neither the shareholders nor the directors of the Indian company and therefore they had no right to sue and consequently the suit itself is not maintainable. It also averred that the disputes between the plaintiffs and defendant numbers 3 to 7 arose around 2013 and the suit had only been filed in the year 2018 and consequently the suit was barred by limitation. Another objection was that the plaintiffs had filed the suit when private equity investors had shown interest in purchasing shares of the Indian company, and the same was an abuse of process of law. Maintainability of the suit was also questioned on the ground that it was barred by Section 89 of the Companies Act 2013 and Section 187C of the Companies Act 1956. Somewhat similar stand was taken by other contesting defendants in support of the prayer for revoking the leave and to rejecting the plaint in CS number 33 of 2018. Defendant number 2 also took the plea that it was not interested in seeking the relief claimed in the plaint, with defendant number 2 is the beneficial interest holder of 6% of shares of the Indian company. Counter affidavits were filed by the plaintiffs with respect to these applications, reiterating that they had the locus, that the suit is within the period of limitation, that the court had jurisdiction to adjudicate the issues, and that the suit had been filled up with bona fide intent. Para. The learned single judge dismissed the applications filed by the defendants seeking to revoke the leave granted to institute the suit and to reject the plaint inter alia, holding that the allegations pertaining to fraud would have to be decided in the suit. He further observed that there were factual issues that were to be gone into, and sections 187C and 89 of the Companies Act, which may bar the reliefs but would not bar the suit. The aforesaid order of the learned single judge has been reversed by the division bench wide common judgment dated August 3, 2018. It has allowed the appeals filed by the contesting defendants and set aside the common order of the single judge, thereby revoking the leave granted by the single judge in the case. Okay, thanks.